The Connecticut mom accused of poisoning her estranged husband's wine with antifreeze is getting out of jail.
You understand those requirements?
Yes, I do.
Kristen Hogan is posting bond that was set at $1 million. We just learned that in a hearing on Thursday.
Okay, so this case is not what it seems.
Her defense attorneys are pushing back on the allegations that not only did Hogan try to kill her estranged husband, but that she allegedly admitted to putting the poison in the wine bottle that he drank from. We'll talk about the unique place that she gets to go once she gets out of jail. We're on The Case, presented by Law&Crime. I'm Chris Stewart. Well, we learned today that Kristen Hogan will be able to live with family as her attempted murder case plays out. This is video of the 33-year-old Connecticut mom entering the courtroom today in Danbury, Connecticut. That's near the New York border. It's in the western part of the state. Now, this is the first time that our cameras have seen Hogan since her arrest for allegedly trying to kill her ex-husband by poisoning his wine with an antifreeze ingredient. Here's her mugshot. She was arrested on October 3rd, but this arrest, according to Connecticut State Police, it was the culmination of an investigation that started in the beginning of August. Now, again, we'll talk a little bit about where she is headed in just a moment. Bail in this case was set at $1 million, and her attorneys say she is posting 10% of that in cash to get out of jail. We'll also talk a little bit about what her attorneys had to say about the allegations, which do seem to be pretty strong according to arrest documents that we have. Now, context of how all of this went down. Hogan has been in a bitter custody dispute with her estranged husband. The two of them share a child together. Hogan told police that they separated back in the spring, and this situation's so bad, one example she gave is that her estranged husband allegedly had her car towed from her possession just because it was in her name. She also moved out of the house that they shared together, and she was living with her parents. Here's the timeline of what led us to today, and frankly beyond. August 5th is really where all of this begins, because Hogan's estranged husband said that day he had family over and someone brought a bottle of wine for dinner. Everybody had some of the bottle. They didn't finish it though, so they corked it. They put it away. 2 days later, so it's August 7th, the estranged husband and Hogan were due to appear in court because Hogan had filed a complaint. Hogan didn't show up to that court hearing though. The man said while he was at the courthouse waiting for Hogan, he got an alert from his Wi-Fi router that Hogan's phone was allegedly inside his house. He did say that Hogan had free range to go into the home that they once shared together. Now, when the alleged victim in this case got home, Hogan wasn't there. A couple days after that, August 10th, the estranged husband said he had some of that wine that wasn't finished at the dinner party a few days prior. And when he woke up the next morning, it was around 6 o'clock, he was sick. He was vomiting. He went to the hospital. His condition was apparently so bad that doctors actually first thought he was having a stroke because he was slurring his words, according to Connecticut State Police. Police say they did test that wine bottle, and it came back positive for traces of an antifreeze ingredient. But that also, and I'll tell you about this in just a moment, that wasn't the only thing in the house that allegedly tested positive for that potentially deadly ingredient. Now, as part of this story was developing, and police were trying to figure out what was going on September 29th, the estranged husband calls Connecticut State Police, who have been investigating this case, and he said that the child that he shares with Hogan, they were in the hospital. The child was allegedly showing similar symptoms to what the estranged husband had dealt with back in August. Hogan allegedly told social workers that her estranged husband could be poisoning their child. And based on those allegations that day, the estranged husband was removed by hospital security. Police then start talking to Hogan, and she told them that she believed her estranged husband was poisoning their child. She also said that she was now living full-time with the estranged husband, but he had told Connecticut State Police that wasn't true. She did, though, have full access to the house. Hogan then told police that she didn't go to that court hearing back in August because she was with her family in Rhode Island, even though, by the way, she was the one who filed the complaint for them to go to court. That was also the day, remember, that Hogan's phone was allegedly inside that house. Police then told her what they found in her search history. They had been able to get her phone. They had been able to look through what she had been searching on the days around that incident involving the wine and her estranged husband going to the hospital. They say that Hogan allegedly searched potassium cyanide, potassium ferricide, citrate cyanide, potassium thiocyanate, and monoethylene glycol. And monoethylene glycol is what her estranged husband tested positive for, and it is what that wine bottle tested positive for. On top of that, she allegedly searched how much those substances, quote, would kill you. And she also searched where one could buy those substances. Before I get back to this episode of On the Case, I need to take a moment and pause and talk about our partners at Morgan & Morgan, America's largest injury law firm. They have more than 1,000 attorneys and they win a lot. They've recovered over $25 billion from more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. In Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. Another client in Pennsylvania received $29 million after being offered only $500,000. Now, even if you don't think your case is worth millions of dollars, why not fight for what you deserve? Morgan & Morgan makes it so easy to start a claim. You can do it with 8 clicks on your phone. So if you've been injured and you need to start a claim, go to www.forthepeople.com/OTC. You can also scan this QR code on your screen or click the link below. And on top of that, she searched several measurements like kilograms to pounds. She also reportedly searched, quote, penalty for not appearing for court hearing on your own motion. And that was a day before Hogan did not appear at that hearing that her estranged husband was at. When state police confronts Kristen Hogan about her search history, Hogan allegedly said she had no idea what they were talking about. She didn't know what these chemicals were, but then she said she did recognize the word cyanide from the TV show Psych, which used to air from 2006 to 2014. Hogan then remembered, she said, that she did buy monoethylene glycol in July, and she bought it off Amazon because she needed it to use it as a cleaning product for a carpet at her mom's house. Then state police laid out even more of the cards that they had according to court documents. They said based on the Wi-Fi information, they believe that she was inside her estranged husband's house, and they told her how he was hospitalized with that same ingredient that she was claiming she used to clean her mom's carpet. And then it appears, according to these court documents, that Kristen Hogan comes clean to an extent. She allegedly told police that she never intended to kill her estranged husband, but, quote, wanted to make him sick as payback for him being mentally abusive. Now, her attorneys are pushing back on that part of the report in some ways. I'll show you what they said in just a moment. Hogan then allegedly said that she didn't measure how much she actually put into the wine bottle, and when she was asked if the alleged poison was put anywhere else in the house, she allegedly said yes. She said she put it in an iced tea bottle. She claims, though, there's no way her child or another child that her estranged husband shares with another woman could have consumed that tea. She claimed her search of how much the chemical could kill you was actually after she learned her estranged husband was in the hospital, not before. Hogan was arrested. She is now charged with attempted murder, and she is also facing a charge of interfering with an officer. And all of that led us to today when Hogan appeared in court with her attorneys. They say she is posting $100,000 cash to make bond. She also will be allowed to live in Massachusetts on home confinement with her grandparents. Now, the reason her attorneys say she has to live out of state is because there's a Department of Children and Families order that will not allow her to be at her parents' house in Connecticut where she had been living. She will also have to wear a GPS monitor, and she'll meet with a parole officer once a week. In court today, we also learned that Hogan will go to the hospital to be evaluated for mental health issues before she heads to Massachusetts after she gets out of jail. There's also a do not contact order between Hogan now and 5 people. Hogan has 2 attorneys representing her at this hearing today. Here is what they told media outside the courthouse.
So briefly, we're grateful that the court granted some of our requests to allow Kristen to get out today. She's looking forward to going to see her family in Massachusetts and be compliant with court orders while we investigate this case.
Can you speak anything about the allegations?
No, we're not going to get into the allegations yet. We don't have police reports yet. We're still in the very early beginnings of an investigation stage.
But in the arrest warrant, it makes clear that she might have made some troubling statements. Are you concerned about how some of that information was extracted and
We'll be looking into everything, okay? So this case is not what it seems. There's a lot more to this story. We can't really get into more details on that. What we do know is Kristen is a loving mother. She cares about her kids more than anything, and she's looking forward to keeping this case moving and resolving it.
How is she feeling with these allegations against her?
I'm not going to talk about that.
How do the civil cases and the probate cases factor in here?
Again, there's a lot of moving pieces here. We're not going to get into those pieces, but we're really now focused on getting the evidence, getting the discovery, and really helping her and helping defend her against these charges. And I do want Ryan to speak as to the evidence preservation motions that were made today.
Well, it goes along with what Attorney Sherman was saying. We need to get the evidence. One of the things that you probably all saw on the warrant was that there were cameras. There were mentions of Ring cameras and Nest cameras and other potential cameras. So what we asked the court to do is to preserve that data, to send an order to Amazon Inc. and Google and make sure that that stuff gets preserved. And again, we'll see what it shows, just like we will with all the other evidence, and we'll take it from there.
but as defense attorneys, how much of a level of concern is the statement? So I didn't want to kill him. I just wanted to make.
I mean,
I
that's
wanted to make him sick.
That's just an allegation, okay? Yeah. We need to see the evidence. Just because it says it in a warrant with accusations and allegations doesn't even mean it actually happened. So we need to look at the evidence.
Joining me now to talk more about this is criminal defense attorney and former prosecutor Safa Robinson Ferrer. Always great to have you on Law and Crime. How common is it on an attempted murder charge, especially with a bond at $1 million, for a defendant actually be able to post that and get out?
It's very uncommon. With murder charges and attempted murder charges, you're always going to see a high bail in those cases. However, most of the time, individuals are not in a position to pay that bail unless they come from some financially wealthy family or have a good enough career where they can afford that type of money. And I think she posed at 10%, which would have made her have to provide about $100,000 cash to be able to bail out. And so with that being said, to be able to come up with $100,000 in cash and to be able to post that type of bail is pretty significant. And that tells me that, she may come from wealth, she may have a good job or have some access to some sort of funding that would have allowed her to post that large amount of cash. Not only that, but the purpose and reasoning for bail is to ensure a defendant's return to court. So the fact that it's a high bail, I think that part of the reasoning is because you want to try to keep someone in custody so they don't come out and reoffend or hurt somebody else or, go at any of the witnesses that may ultimately testify against them. So that's one reason why we see the high bail, even though statutorily, at least here in New York, that should not be the reason for it. But you see that. And also to ensure the return to court, because these are high stakes charges and she could possibly spend a significant time in prison, you want to ensure that the person isn't just going to get out and flee. And setting a high bail to that number is pretty common, like I said, to ensure that return.
Because I think that there's probably a lot of people facing charges like she is, who are going to spend the amount of time it takes until this case would go to a trial in jail and not have the money to be able to post $100,000. Because what's the difference between, and the attorney talked about this, that it was 10% cash and not a surety bond. What's the difference between the two?
So I'm not too familiar with the bondsman's math is not my forte or insurance.
Sure.
But basically what the court says is, okay, your bail is, $100,000 cash, $1 million surety bond. What you often will see is at a certain percent, usually at 10%, which in this case is $100,000. That person must provide that in cash to the court, the clerk, to ensure the return. Or if there's going to be some sort of bond or surety bond, you go to a bail bondsman and either put down a certain percentage. And sometimes you see people put up their houses or other items that have significant value to ensure that a person can get bail and return to court without having to sit in custody to face the charges.
And she's going to be able to go, and I know her attorney said it was kind of unique. And, Connecticut's a small state. It's not like a Texas or California where, state lines are a little bit closer than in other places. But she's going to be able to leave the state and go to Massachusetts and live with her grandparents and check in with a parole officer once a week. So she'll have that going on, and she'll go to a hospital for a mental health evaluation. As we dive into this case, and certainly if everything that police are alleging is true, I mean, the effort that went into trying to poison, allegedly, this wine bottle is certainly stunning. The defense, though, says it's not what it seems. How does a defense attorney, especially considering, according to police, they have a somewhat of a confession that she put this antifreeze into a wine bottle, how do you approach that in this case?
Yeah, so there's a lot of things at play here. We have the allegations in and of itself where, she's alleged to have attempted to murder her estranged husband or partner. You've got maybe things where they might have family court petitions going on, and there may be some litigation in the family court world. Also, you may have some sort of mental health at play here as well. Again, unfortunately, we do see murders occur as a part of, the society that we live in. But, who wants to just go out and, kill somebody? There's got to be something there that, especially if it's not in defense of yourself or an immediate defense of yourself, we have to look at what's really going on here that would cause someone to allegedly poison their partner. And if there are any mental health factors at play, is there some sort of domestic abuse that had been going on prior to this incident happened in which she was the victim? So all of those things are at play. Also, at the point in time where she had conversations with law enforcement officers or the investigators, that's going to be key here. It appears that they did get a confession from her, but whether or not that confession was obtained legally is going to be a question that her attorneys will have to explore. If there was any coercion, if she was Mirandized properly, and if she waived those Miranda rights unequivocally and gave that statement possibly incriminating herself, are going to be all things that the attorneys look at and challenge as the case proceeds to trial.
We know that the relationship it appears that she has with her estranged husband is not good. He towed her car because it was in his name, she says, and she's living with her parents and he's at the house, and a tough situation, especially when you have a kid. If there is, and I don't know if there's domestic violence, but she said he was mentally abusive. So if you have this relationship, and I could see a jury being sympathetic to that to some extent, that this, toxic relationship's ongoing, you would still, if that's admissible, have her putting antifreeze into a wine bottle that anybody could consume. Like, how could that play out? Kind of this, yes, you were having a very tough time with your estranged husband, but I also think there were kids in the house, not that they'd be drinking wine, but anybody could have come over and had that wine if that's actually true.
Absolutely. And that's the thing that's going to be what we call is just a bad fact for the defense. How are you going to get over the hurdle of her possibly or allegedly voluntarily putting antifreeze into a wine bottle for him to drink? It's not like that's a situation where she was under immediate attack and had to defend herself or was justified in defending herself. So how do we get around that bad fact as the defense? And it certainly is a bad fact that the prosecution is going to look at and really hone in on as they continue to try their case. And that's really going to be the point where, the prosecution is going to get up in front of a jury and say, she intentionally attempted to murder this individual. And how do you formulate intent? Well, she did A, B, and C. She took her time out to get antifreeze. Maybe she purchased that at a store or she had it in the garage. At this particular point in time, she put it in the wine bottle, and, between day 1 and day 2, he consumed it and began to fall ill. Ultimately went to the hospital. There were some tests run, and that confirmed antifreeze in his system, which further would confirm that she, if they can prove her identity as the person who had done that, did in fact intend to murder this individual.
When it comes to her search history, because that seems pretty damning if that's true, because it seems like there is a search to go with specifically everything that the Connecticut State Police say that they found in this investigation. And the part that stood out to me was her saying, I don't know how much I put in there. I don't even know what these chemicals are. But then she's searching like kilograms to pounds and like the ratio you would need to do things. I guess for the prosecution, I mean, how do you have this information? How would you present that to a jury if this case even goes that far?
Yeah, absolutely. So one of the things you want to do, whether you're a prosecutor or a defense attorney at trial, but primarily if you're the prosecution, is you want to tell the jury a story. you want to paint a background in which it appears that, there was this relationship between these two individuals, things went south, and it became very conflicting between the two. And as a result of that conflict, that violence, that tumultuous relationship that they had, there started to be things in which this particular defendant started to do in an attempt to get rid of her partner, her ex-partner, her child's father. And one of the things she had done was try to concoct a plan to poison him. And she did that by reviewing And she did that in a number of ways. She planned it out. It was premeditated. How do we know that? Well, we have her cell phone records, and I'm going to put a witness on the stand to testify about her cell phone records, subpoenaing the history, so that as I'm telling the story to the jury about what happened, I'm showing them physical proof of these searches. Now, the defense is going to get up and say, well, you can't prove that she was the one that was actually searching in the phone at that particular time. But if we have her admission saying, well, I, looked into this, I didn't realize how much or pounds or X, Y, and Z, that's going to be a tough fact for the defense to swallow. And I think that what often happens is you have people who want to tell their side of the story in a way that takes some accountability, but because what they think that they are telling the police would negate the culpability for criminal action, and it really doesn't. It just continues to put them on the hook and perpetuate the narrative that, yeah, you did intentionally do this, and these are the facts that support that. So although you didn't know how much you were using, you think in your mind it can't be attempted murder if I didn't know. Well, yeah, it can be.
For the estranged husband, and he actually had an attorney who just appeared in court, said she was there for the victim, and that was the only statement she made. I guess, and I know the prosecution's going to prosecute his now estranged wife, but from his standpoint, I mean, is this like a civil action? I mean, he has an attorney. Like, what role would an attorney for the victim in a case like this play?
So attorneys for victims, a lot of times there could be a civil action that ultimately comes from this. If he has some sort of damages or, medical diagnoses that at this point are as a result of that act that allegedly occurred, then they can advocate for their client on that behalf. Not only that, but they have the ability to advocate for their client through other attorneys, through the district attorney's office, and to be in communication with the district attorney's office to ensure that their victim is fully cooperative with the prosecution and that they can aid in the prosecution with going forward and ultimately coming out with a conviction on these charges on behalf of their client. And again, any monetary damages that they may be entitled to because of physical damage from the incident.
I don't know specifically what Kristen Hogan does for a job. I know she worked for like a nonprofit at one point. She's obviously posting $100,000 cash, which is a pretty large amount of money to post as she's facing these difficult charges. The attorneys she had today were both they seem to be high-powered lawyers, and they seem to be their partners at their law firm. She had the two of them with her in court. When it comes to, even a case where it does seem like the prosecution has a lot of evidence, like what does one of those top-tier, someone like yourself, like a top-tier defense attorney bring to the table, not saying that a public defender couldn't do it, but what you get at that extra level that the prosecution would have to prepare for?
Well, what you're going to get is you're going to get an attorney that's going to pay very close attention, and you're really going to get a bulldog. And I'm not to say, to your point, that, public defenders aren't like that, but at the end of the day, public defenders are overworked and underpaid. And when you get a private attorney like myself or these attorneys, you're paying for attention to the case, which all attorneys should give, but you're also paying for, our experience and our ability to truly challenge and go after the prosecution with what we would believe are false allegations. Not only that, but we have investigators that work on our behalf. You may not get that with the public defender's office all the time. And you have people that really are going to be a support system to you as the client. A lot of times our clients become family. We're working tirelessly day, night, and over the weekends to be able to advocate for our clients and put our clients in the absolute best position possible. And we have dealt with so many complex and intricate cases that we bring that experience that sometimes no other attorney can. So I expect that, her decision to retain these particular attorneys, again, they're high profile, high priority attorneys, considering the amount of money that she was able to post with bail and who these attorneys are. There's somebody probably along the line that has pretty good financial backing to be able to provide this aid to her, and these people will be able to successfully advocate for her.
Yeah, and we'll see. I mean, they had some motions today granted. She'll be in Massachusetts. She's going to be out, be able to be out on bail as she's facing
And that's a
murder.
huge win at this point too, because most judges, they're not going to want these individuals to get out of custody because they don't want them to reoffend as their case is pending. So that's already a win that we're seeing on behalf of these attorneys. And I can tell you this, if she was represented by the public defender's office, she probably would still be in custody at this point during the pendency of her trial. But again, because of the skill of some of these attorneys, they were able to get a bail package for her that was sufficient and appropriate enough where she can go home, stay out of state with her family, and come back when necessary.
And on that, and again, I don't know what her financial, I'm just assuming based off the money she's put forward, the attorney she has, that there's some money there. Does a judge, when they set a bail, look at someone's financial background? Because I could see in some cases where, there was a story out of Texas I covered this week, there's a $14 million bail. There's no way that person would ever be able to meet that. In Connecticut here, it's $1 million. A lot of us wouldn't be able to, in her situation, be able to meet that, but clearly she has the financial ability to do that. Is that something a judge would look at ahead of time and say, hey, I'm going to set it at a level that you're really going to have to jump high to get to if you're going to get out?
Every state is different in terms of their bail laws, but that's really not something that the judges should be looking at. You really should be looking at the case, to the extent of, is this a bail qualifying offense? And if so, what is reasonable bail that will ensure a defendant's return to court? You don't want to set such a high bail that someone can't, meet that bail and they ultimately sit in custody, especially if they're truly innocent of the crime. And we've seen individuals who have harmed themselves and committed suicide because they have not been able to get out of that very difficult system of, pending prosecutions, staying in custody at, for example, Rikers Island and these other facilities. Yeah. And so, judges really should not be looking at a person's financial status and should just be looking at the facts that are appropriate for that arraignment process. But do judges do it? Absolutely.
Yeah, and so she'll be in Massachusetts for now as it plays out, and we'll see what happens. Safa Robinson Ferrer, it's always great to have you on Law and Crime. Thanks for being with us.
Thanks for having me.
That will do it for On the Case, presented by Law and Crime. Subscribe to us on YouTube and Spotify. I'm Chris Stewart. We'll see you next time.